and thank you all for coming. My name is Jennifer Seidel, and I'm very honored to be doing the introductions today. McGill is situated on the land which has long served as a site of meeting and exchange amongst Indigenous people, including the Haudenosaunee and Anishinaabe nations. The McGill Center of Human Rights and Legal Pluralism is honored and respects the diverse Indigenous people connected to this territory on which we gather today. Thank you all for attending.
Thank you very much. Welcome to the McGill Faculty of Law. I was asked to say a few words about the Humphrey Lecture, and whenever the history of something is given to everyone in their programs, it always feels like it's a reading test for me. You're welcome to read this. We're thrilled that this marks 30 years since the Humphrey Lecture was established, but it struck me it would be more meaningful if I said a couple of personal things that haven't been distributed to you in the program. So I'm going to say just a couple of things about the Humphrey Lecture and the legacy of John Humphrey, a little bit about the Center for Human Rights and Legal Pluralism, and just a couple of things about our guest speaker of honor today, John Borrows. So the legacy of John Humphrey is alive and well, and something felt in the faculty often. There are moments where people at McGill gather and are trying to think of major ways in which McGill has left a mark on the world, and decades after, people still often turn to John Humphrey and his role in drafting the Universal Declaration of Human Rights. And so to be here today at a Humphrey Lecture is very meaningful for me. The Center for Human Rights and Legal Pluralism, which organized today's event, many of you are actively involved with it. Those of you who aren't, the Center is one of the kind of fast-beating hearts of the Faculty of Law. The Center receives people from all around the planet who come to McGill with a passion for justice and human rights, and it makes their stays extremely meaningful. The Center takes people from the Faculty of Law and helps launch them out to a whole range of experiences. So the Center is extremely vital. There's always things going on, and many of us learn all the time from our engagement with the Center for Human Rights and Legal Pluralism. So I want to acknowledge the whole team that has organized today's events and many others. And last, about John Borrows, it's a thrill for me to be here at this public lecture by John. The discussions around whether he would be able to spend time with us during this academic year began very shortly after I took over the deanship, and we talked about what some time with us might involve, and it would involve some time teaching and learning with the teaching colleagues. It would also involve a public dimension, which you're here to experience today. We've, of course, had many distinguished visitors over the years, and some take very seriously engagement with the community when they're here, and others kind of hole up in their office and shut the door and focus on their writing. I'm really thrilled. John tells me he's actually writing, but he has certainly been very present in the life of the faculty. He's supervised term papers, which for a visiting person on sabbatical from his home institution is quite extraordinary. But you've really been very generous in sharing your knowledge and experience with us, and so I want to acknowledge that publicly, and thank you for that. Jennifer, you're going to give us more details about John, but I wish you a wonderful and stimulating, and challenging, perhaps, Humphrey Lecture this afternoon.
I'm truly honored to actually be introducing Professor Borrows. I still remember the first day in which I started my university degree, and it was one of the only Indigenous scholars I read, which was such a rarity, and it had such an impact, and it actually led to me completing a minor at the University of Toronto in Aboriginal Studies. So I can't believe I'm meeting you, met you this year. We are fortunate at McGill to have you and have you host you here, and you have truly made an impact on the field of Indigenous law. Professor Borrows is the Canadian Research Chair in Indigenous Law at the University of Victoria. In 2017, he was named the Killam Prize winner in Social Sciences. Some of his publications include Recovering Canada, The Resurgence of Indigenous Law, to which he won the Donald Smiley Award for Best Book in Canadian Political Science in 2002. He also published Canada's Indigenous Constitution, which won Canadian Law and Society Best Book Award in 2011. And then my personal favorite, which was published and we read within Foundations last year, was Freedom and Indigenous Constitutionalism, which also won the Donald Smiley Award for Best Book in Canadian Political Science in 2016. Professor Burrows is Anishinaabe, Ojibwe, and a member of the Chippewa of the Nawash First Nation in Ontario. And now, if you can please put your hands together.
Buju Ginawa, Miigwech Biajayag Nyongum, Giganos Indigenikas, Neashi Winnigamingandon Jabana Gigandodam. I'm grateful to be able to be with you today and deliver this lecture. I'm thankful for the generous hosting that I've received as I've been here at the university, and Dean Leckie has made a huge difference in that regard. I'm also very happy to have met so many students during my time here, starting on my reserve in September as students came from this institution to the Bruce Peninsula to learn with myself and other teachers and elders in that place, and it feels like it's just continued since then. I'm also grateful for that very kind introduction as well. Today I'm going to talk about this concept as listed here regarding Indigenous rights as constitutionalism. And I want to do so in the context of implementing the United Nations Declaration on the Rights of Indigenous Peoples. The point of this talk is to develop, there's a spelling mistake there, the relationships between colonialism, rights, declarations, and legislation. And I'm going to go through three parts as we're together: the contingencies of rights, Indigenous rights as colonialism, and then UNDRIP and the attempt to implement those rights. So that's the threefold nature of the lecture, working through these relationships of colonialism, rights, declarations, and legislation. The theoretical approach that I'm taking is that there is no traditions that are metaphysically pure. That includes Indigenous and European or other traditions. That therefore my comments are grounded in the messy world of physical experience. That takes seriously the notion that Indigenous people's lives are shot through with relations of inequality, force, fraud, broken promises, failed accords, degrading stereotypes, misrecognition, paternalism, enmity, and distrust. And recognizing that this is the moment that we live in, it's not just historic. But only as a part of this, not just seeing this as a part of our world, because Indigenous peoples also live lives that are saturated with Nbwakawin, Zagiduin, Maanain Dinuin, Akwadizuin, Dabadain Dizuin, Gwekwidizuin, and Debwewin. That is, our lives are also beautiful, and there's so much to draw from in terms of the possibilities in the ways that we're living together with one another as well. This idea of not starting with an a priori or pre-existing frame is to take seriously the insight that we live in a customary legal world, and we can't just start from these abstract forms in the way Plato or others might talk about things. So in the contingency of rights, as I'm thinking about this idea, I want to make the point that rights discourse are both simultaneously liberating and limiting. Rights are limiting when they are essentialized, universalized, and placed above the fray of human affairs. I know that people will disagree with that. They can be dangerous when they're abstracted from real-world struggles faced by ordinary people. On the other hand, rights can be liberating if they're used as political tools. They create opportunities to either challenge or facilitate government action. When rights are regarded as real-world rather than metaphysical instruments, they can then be strategically deployed or discarded, given the grounded context in which they operate. That is, rights are not heavenly endowments or intellectually pure forms. They're very human constructs, and as such are not beyond human manipulation. As Oliver Wendell Holmes observed, the life of the law has not been logic, it has been experience. Now, the experience of Indigenous peoples within Canada's Constitution highlights the composite nature of our rights, and that's what I'm going to talk about today with you. Indigenous peoples have found rights to be both liberating but mostly limiting. Aboriginal rights within our Constitution do not flow from an ultimate convergence in values, There's widespread disagreement about their nature, scope, and purpose. And reconciliation is picked up as the purpose of Section 35, to reconcile the pre-existence of Aboriginal societies with the assertion of sovereignty by the Crown. And in my view, this notion of reconciliation, this abstract aspiration, has problematically dominated the jurisprudence dealing with Indigenous peoples. In my view, reconciliation is a flawed metaphor in this field. Any compromise with colonialism causes us to be compromised by colonialism. It's not enough just to saw off the differences between problematic and laudatory visions of Canada and our constitutional narratives. We must reject colonialism, not just as an historic experience, but as a present structure. And therefore, we should not try to reconcile Indigenous peoples and others to it. We must not harmonize racism with our higher principles. Constitutionalism is a living force and must be rejected. So I'm going to argue here that rights have their downside as they're cast in this frame, and they can even be undesirable because they get in the way of human flourishing. If we claim that rights are fundamental, in my view, we overreach. Such claims can create false horizons and limit our imagination and action in the real world. Rights discourse may prevent us from seeing other viable alternatives and challenging domination. In this respect, I am anti-fundamentalist when it comes to rights and other essentialized legal constructs. In fact, I worry when rights attract an almost religious aura in legal circles. A faith in their disembodied reality seems analogous to a hollow faith in a form of God. Rights discourse often replicates forms of dogmatic, doctrinal adherence that echo religious sectarianism. Rights followers can even be divided into different denominations, such as those who see political rights as separate from economic and social rights. Of course, some rights followers are more ecumenical, and they do not see dichotomies between political, economic, and social rights. But nevertheless, in all of these versions, potentially, the seemingly elevated status of rights troubles me. If not put into context, for religionists, it would seem to border on idol worship, to replace God with a human construct like rights. And if one does not believe in God, it may nevertheless be troubling to see how rights can attract the kind of reverence and deference that religionists often reserve for God. As a thought experiment, I can almost imagine the first 4 commandments of rights discourse. And rights spake all these words, saying, I am rights, thy pre-existing form, which have brought thee out of the pre-societal state of nature, out of the house of bondage. Thou shalt have no other pre-existing forms before me. Thou shalt not make unto thee any other preeminent pre-existing form, or any likeness of any other a priori form that is in heaven above, or in the earth beneath, or that is under the water under the earth. Thou shalt not bow thyself down to them, nor serve them. For I, rights, am a jealous pre-existing form, visiting the iniquity of the fathers upon the children unto the 3rd and 4th generation of them that hate me, and shewing mercy unto the thousands of them that love me and keep my principles. Thou shalt not take rights, thy a priori form, in vain, for rights will not hold him guiltless when that taketh his name in vain. Now, when I asked my colleague Benjamin Berger, who teaches at Osgood, for his feedback about this analogy, he wrote following. He says, I like your move from a non-fundamentalist approach to the religious analogy. It struck me that your claim had more to do with rights discourse taking on the worst form of religion, what religion can look like when it takes a wrong turn. And that wrong turn is when it takes on idolatrous forms. Idolatry seems to me when one replaces substance with form and makes sacred an essence at all, thereby stalling our spiritual movement. Idol, I-D-O-L, / idol, IDLE. Thought about it in this way, I wonder what's going on. I wonder if what's going on is that rights discourse can begin to take on features of excess faith in the abstract, just like religion, when it stops tracking the real. And so Ben, in thinking through this with me, wrote back this, I think, interesting form. Our rights, which art in charters, hallowed be thy claims. Thy kingdom come, thy will be done, on earth as it is in theory. So with this as a background, thinking about the contingency of rights, I now want to talk about some of the ways that we're challenged by rights in the Indigenous context. And I want to talk about proof of rights, scope of rights, and infringement. So first of all, regarding proof of rights. Indigenous peoples have a difficult time in bringing their claims before the courts because of the burden of proof. They were here long before other people came, yet they're the ones that have to establish that they were here prior to contact, prior to sovereignty's assertion. Why is it not the Crown that has to justify its claims in the way that it often asks of Indigenous peoples? And to ask the question, I think, is to preface the answer. So this burden of proof is very difficult for Indigenous peoples to have to establish that they have the opportunity to access the goods of the state, to access their own legal traditions, their own political cultures in living in this country. There's also a problem not only with the burden of proof, but the theory of proof. Indigenous peoples in Canada live with a form of originalism. It's actually built into the word aboriginalism. And that is a conservative way of thinking about constitutional interpretation. If we haven't agreed to something in the past, or if something in the past wasn't there in those founding moments, we cannot claim rights for those practices today. Most of the Constitution, as you know, operates in accordance with a living tree understanding of constitutionalism for Aboriginal peoples. We have to go back to what was integral to our distinctive culture prior to the arrival of Europeans. And if we did something after Europeans arrived to respond to their presence, we cannot claim rights that would flow from those practices. That, in the Van der Peet case, is calibrated pre-contact. Our rights maybe go back to the 1500s in some places. In the Aboriginal title context, the originalism is the assertion of sovereignty by the Crown. In the Delgamuukw case, the court said, because it does not make sense to speak of Aboriginal title before the Crown existed, Aboriginal title crystallized on the assertion of sovereignty. So there's no such thing as Aboriginal title until the Crown comes along and engages in that magic crystallization process. But you can see the originalism that's involved in tying claims to land to that moment. Treaties are also originalistic because what the cases say is that you have to reconcile a common intention at the time of the negotiation between the parties. And the only things that Aboriginal peoples can claim from the treaties is what was in the minds of the parties in those moments. Well, what are the alternatives? There's a theory in the United States out of a case called Winans from 1905 that treaty rights create reserved rights. If it wasn't in the mind of the parties, then everything else is reserved to Indigenous peoples from that point forward. If you didn't negotiate it or talk about it, Indigenous peoples get to keep the thing, whatever it is, as it would develop off into the future. The United Nations Declaration on the Rights of Indigenous Peoples, both on the burden of proof and the theory of proof, would just have us start with Indigenous peoples have the right to self-determination. These kinds of burdens are not as onerous in that form. But then we have problems with the forum in which the proof is required. It's procedurally European, it's substantively European. The court does have a framework that says we have to take Indigenous rights on a sui generis basis, using both Indigenous perspectives and common law perspectives. But that, by and large, takes place in a context which is mostly missing Indigenous legal insights through and through. An alternative would be to build a trans-systemically purpose-built institution where not only the procedure but the substance by which you judge the procedure would be formulated by the parties sitting down in advance and negotiating how it would be that they would resolve the conflicts that they have between them. The Treaty of Waitangi Tribunal is a loose analogy to that. And then, of course, there's the problems of resourcing proof. Cost of bringing actions, the personnel to bring the actions, the capacity of the parties, particularly Aboriginal parties, to bring the actions are seriously unbalanced. It estimated that it cost $25 million to bring the Delgamuukw case that ended in 1997, saying there was such a thing as Aboriginal title, but they didn't have the sufficient moment to prove that in the context of that case. $25 million. And then $40 million to be able to bring the Silcotin case. For 2 cases alone, right, $65 million to be able to launch an action to show that you have title to a place as a serious unbalance. I would like to think about ways to resolving that that would, again, be more in line with Indigenous legal traditions and their participation. What would it look like to have a public Attorney General that is in charge of protecting Indigenous rights? Much as provinces have Attorneys General, the federal government has an Attorney General. There's nowhere in the system where someone is watching out in quite that strong way as you see in the rest of federalism. What would it be like if the provincial or federal governments, through their honor or through a trust obligation or fiduciary duty, set up a department that their sole purpose was to protect the rights of Indigenous peoples that were in their jurisdiction, and then put that opinion forward as other ministries are putting forward their points of view. So there are challenges with proof of rights, and I think you can see why Indigenous rights are colonial if you have to run this gauntlet to be able to make your claims. But it's not only those, we also have the challenge with scope of rights. In the Sparrow case, which was the leading case dealing with Aboriginal rights in 1990, the court found that Aboriginal rights were those rights that weren't extinguished before 1982. And so if in 1982 an Aboriginal right was existing, then it could be recognized and affirmed. That was a great victory for Aboriginal peoples to know that the regulation of our rights did not lead to their extinguishment in the way the courts thought about that. But if we think about the other side of that case, it's also a huge loss. Because what Sparrow did is it actually accredited the power of the government to extinguish unilaterally Aboriginal people's rights prior to their constitutionalization. By one stroke, it's possible that decision wiped out more rights than anything that we could gain subsequent to that by arguing through the courts, if indeed the court finds that there's been a clear and plain intention to extinguish unilaterally again prior to 1982. The other challenge, of course, is that there's a bias towards federalism in dealing with rights in Canada. The federal and provincial governments and the challenges that they face are often given priority. They're preeminent in our constitutional spheres, and Aboriginal peoples fall between the gaps of those spheres. And a recent case, Grassy Narrows, said that laws of general application that the provinces pass can apply to Indians without a legislative amendment like Section 88 of the Indian Act. And by that direct ability of the province to be able to apply their laws to Indians, that takes up valuable constitutional space that would otherwise be available for Indigenous peoples to exercise their own powers within that sphere. And so this bias is there as interjurisdictional immunity is diminished, as you find just the general course of events favoring those parties. There's also many things missing in thinking about rights under Section 35, in particular sovereignty. In 1996, in a case called the Queen versus Pamajuan, Ojibwe people said, we've been gambling since before Europeans came. We've been engaged in economic pursuits. We've been governing our communities in relationship to those economic pursuits. And the court said, you're framing that way too widely, because an Aboriginal right to self-government is not something that can be generalized. You have to engage in an activity-by-activity analysis. And when we look at the particular activity of gaming, yes, you did game, you gambled prior to the arrival of Europeans. That might have even been important to your culture, but the scale of that gaming wasn't a 20th century scale, and therefore it's quantitatively different than what you did prior to us coming here. You can't claim that as a right. And so our rights to governance were cut out of Section 35, and the scope of that section means that it's just considered beyond our ability to make generalized claims to govern ourselves in our community. We can't actually put that forward as protecting us under Section 35. We have no cases about education or child welfare. You would think if there was something that was integral to distinctive culture prior to the arrival of Europeans, it might be raising your kids and teaching one another. But when these cases have been heard, the court said we don't have enough evidence to be able to make this finding in this particular case that you have these under Section 35. There's been some cases in healthcare that have recognized that it was integral to the instinctive culture of peoples prior to the arrival of Europeans to take account of and help in our bodily and physical and other dimensions of our health, but it's not gone in any large way to protect Indigenous peoples with the tragic outcomes that we face in healthcare. When we die early, we are chronically suffering from so many diseases that people are not generally suffering from. Our life expectancy is 15 years lower than non-Aboriginal peoples. And when you see in child welfare that 80% of the kids in care in places like Alberta, Manitoba, and Saskatchewan are Indigenous, you think about our educational outcomes. We receive so much less funding. Our kids are hardly getting out of grade 8, much less out of high school. This is missing in terms of the scope of rights. Economic development, compensation for loss has not even begun to be addressed in Section 35. So, the Crown used Silcotin land for 100 years and took forestry products and minerals out of the ground and agriculture. There's been no accounting for costs in that loss, even though there's a recognition that those people have that title when the Europeans arrived. They continued to have that title after the Europeans came here, and they have exclusive possession of that today. When someone uses your land for 100 years and takes value from it, you would expect at some point there to be an accounting for that in law. That has not occurred so far. Courts have also found that when we do have our rights recognized, there are inherent limits that are attached to those. Those can be positively framed, that those inherent limits are there and designed to be able to protect our relationship with those territories through time, but that inherent limits doctrine can also be regarded as being very paternalistic. Like, we'll decide for you what we think is in your best interest, and what will go beyond those inherent limits might be one of the possible ways that this scope of right is diminished. In some of our economic development cases, like the Marshall case, the court said, yes, you have a right to fish for eels in this harbor in Nova Scotia, but it's only for subsistence purposes. Never mind that the Crown can issue licenses and people can get rich off those licenses flowing from that very same treaty. Indigenous peoples are left with whatever subsistence means, which often draws on stereotypes about how Indigenous peoples lived once upon a time, and doesn't often consider the contemporary economies. So you get an economic discount, and this is also taking place in relationship to land. The Musqueam Reserve, west of Vancouver, outside of the UBC endowment land, some of the most expensive real estate in Canada. If it's leased land, it gets a 50% discount because of the limitations on alienation that are part of that status of land. And then, of course, there's this recent case called Tinaka coming out of British Columbia, where the scope of Aboriginal rights does not extend to the scope of charter rights under Section 2 does not extend to the object of what people might be wanting to protect. In that case, a spirit bear was regarded as being in a glaciated area where a corporation wanted to put a ski resort in, and the court said, you can't protect the spirit bear. You can manifest a belief in the spirit bear. You can practice your belief in the spirit bear, but we're not going to protect the site where that spirit bear is allegedly to rest. And so the scope of the right under Section 2 is quite limited in that regard. So proof of rights challenges, scope of rights challenges, and then infringement of rights challenges. It is true that the Crown's sovereignty is constrained under Section 35(1), right? If the Crown wants to do something and an Aboriginal right is involved or a treaty right is involved, it has to justify its action by having a valid legislative objective and acting honorably. But let's not forget that this analysis is directed towards the infringement of Aboriginal rights, the diminishment of Aboriginal rights, the cutting back of Aboriginal rights. So even though the Crown's sovereignty is constrained, that constraint allows the Crown to continue to pursue its objectives in relationship to Aboriginal peoples and their rights. So here's a scenario. Imagine how you would feel. And I'm going to talk about consultation and accommodation. So one of the ways that Indigenous peoples it's one of the ways that corporations or governments can justify the infringement of Aboriginal rights is if they consult with Aboriginal peoples, talk with them. And then as that consultation unfolds, accommodate them, right? Respond to what you heard. This is a very enlightened policy in many ways, again, miles ahead of where we were prior to 1982. But even though we should celebrate those positive aspects of that decision, let's not forget we're consulting to diminish rights. We're trying to accommodate the narrowing of those rights. So here's a scenario. Imagine how you would feel if a corporation knocked on the door of your church, workplace, or home and said, hello, you might not know us, but we're building an X project through your neighborhood. In order for us to make money, we would like to consult with you about potentially infringing your constitutional rights to religion, conscience, speech, assembly, mobility, life, liberty, security, equality, or other rights or freedoms that you might possess. After the shock of this declaration wore off, you might not likely be mollified, at least initially, if the corporation's representative said, don't worry, we'll accommodate your concerns about these rights that are going to be eroded. Now, as corporations are designed to operate in their own best interest, which primarily involves maximizing their own investors' wealth, you might be suspicious about whether accommodation was possible and what it might accomplish in these circumstances. Furthermore, you'll already be busy doing other things, and you might find the sudden intrusion of the corporation's objectives on your time and other priorities to be very taxing, particularly if you're a small group without a lot of resources. You might not want to support the corporation's activities in your church, workplace, home, or environment. This example demonstrates that we must never lose sight of the fact that consultation and accommodation exercises are designed to take away something that is protected under Canada's highest laws, our Constitution, even if the process is designed to give something in return. Moving further into the hypothetical, we could say the corporation's representatives next might say to you, governments have allowed us, the corporations, to work with you to determine how much we can cut back your rights, even though the governments possess the ultimate responsibility for what we are doing. When you hear this, you might think the government has put the fox in charge of the henhouse. Now, while these analogies are never perfect, they convey some of the challenges in working under Section 35(1) of the Constitution and why we might sometimes consider rights to be colonialism in the Aboriginal context. Corporations are often seen as government-like agents deployed to do the government's dirty work and further eroding Indigenous rights. The other part about what we rarely do when talking about these rights is to consider the obligations that lie on the other side of the rights. So Hofeld said whenever there's a right, there's an obligation. So if ever you pick up the rights end of the stick, the obligation is on the other end of that stick. This notion of the reciprocity of rights and obligations has not been taken very strongly in our jurisprudence, but it is to say, Section 35.1 says, the existing Aboriginal and treaty rights of the Aboriginal peoples of Canada are hereby recognized and affirmed. Which is also to say, the existing Crown obligations of the Crown and right of the province and the federal government are hereby recognized and affirmed. Right? This is not just about Aboriginal rights, this section. It's also about obligations that might be owed to Indigenous peoples when a right has been found. And these obligations can be quite voluminous, and yet we rarely see them put forward in these kinds of lists to help us understand some of the things that are required of the governments in these circumstances. Recognition, affirmation, reconciliation, non-extinguishment of rights without consent, preventing historic justice, not imposing unduly unreasonable hardships, etc. These are the parts of the law that are there, but it's often like, what do Aboriginal peoples want, as opposed to what is the government required to do in those settings. So we've talked about two challenges so far, the contingency of rights, and then how the rights themselves that Aboriginal peoples experience are colonial because of their proof, scope, and justification for infringement. So let's move now to UNDRIP. This is not an alternative to rights, moving legislatively to try to implement Indigenous rights. It's just another area for struggle. If there are no such things as universal, it's another site where Indigenous peoples try to work through their potential protection in broader spheres. As you know, Bill 262 received second reading in December of 2017. Romeo Saganash, his private member's bill, has been accepted by the government so far with the intention that it will become the law. Here are its provisions. You can see Aboriginal and treaty rights are not to be considered as being abrogated or derogated as a result of the passage of this bill. Likewise, the United Nations Declaration on the Rights of Indigenous Peoples is not to be considered as being abrogated or derogated by the passage of this bill. Section 3 here affirms UNDRIP as a universal international human rights instrument with application in Canadian law. The government, Section 4 there, of Canada's laws and consultation and cooperation with Indigenous peoples must take all measures necessary to ensure that the laws of Canada are consistent with UNDRIP. Section 5 there, a national action plan in consultation and cooperation with Indigenous peoples to implement what's there in those prior sections. And then finally, an annual report to Parliament. So this is trying to work something into the legislative sphere, perhaps because we've just been so dismally unsuccessful in the judicial sphere. The U.S. experience has been quite successful in this regard, not with UNDRIP, but in legislating what's called recognition legislation, where these fields have preambles that say Indigenous peoples have the inherent right to self-determination, inherent sovereignty. Their powers existed before the United States came into formation. Tribes are not created by the Constitution. They're not subject to the U.S. Constitution. And given their authority in that regard, we will, through these pieces of legislation, recognize your authority and extend resources to you around children, religion, resource use, education, governance, law, financing and business, culture, and social issues. Since Nixon made a speech in the 70s indicating that self-determination was the policy of the United States, there's been over 40 statutes that have been passed that basically take as their starting point the inherent sovereignty of tribes, as they're called in that setting. And these pieces of legislation have been passed by and large with the support of Indigenous communities throughout the United States. In fact, commentators claim that in the last 40 years there's been not one piece of legislation that has received the active resistance of the majority and even large portions of Indigenous peoples in the United States. The courts in the United States for Indigenous peoples are a disaster. The Congress has actually done quite well in trying to implement a view that says these rights are in that state. In 2016, in the summertime, the federal government released 10 federal principles. Now, this is all by way to say, if you're reading between the lines with these slides, that Bill 262 is not enough to be able to implement the United Nations Declaration on the Rights of Indigenous Peoples. Right? The bill itself says they need a plan, needs to be annual reports. There's going to have to be further legislative action to bring to pass the implementation of these principles. And these federal statements might show that there's possibility to bring us into some of that legislative universe that we're seeing in the U.S. context, recognizing self-determination, reconciliation, honor of the crown, cooperative federalism, treaties, FPIC, free, prior, and informed consent, justifying infringements, renewing a fiscal relationship, regarding this as a process, not just a one-time event, and then having a distinctions-based approach, so an asymmetrical federalism, as it were, amongst Indigenous peoples in the way that legislation might unfold from that point forward. So I expect, if the government stays in power, that after Bill 262, we will start to see legislative initiatives in particular fields that will implement these principles and that might draw some kind of analogies, loose as though they may be, from the kind of enabling legislation that we see in the U.S. context. We should critique this, right? This is dependent on the will of the majority, right? If the rest of Canada agrees to this through their elective representatives, then we will get this legislation, but it's not something that Indigenous peoples can do on their own and therefore leaves them dependent. And that's not a situation that Indigenous peoples have sought, and for 30 years, 40 years, since 1982, have often explicitly eschewed, saying we don't want legislation. We want constitutional recognition, and then we want negotiation that flows through constitutional recognition to implement our rights. So this is a problematic. We're also asking the federal and provincial crowns to restrain their own sovereignty. That's really what you're doing here. And for the federal government, through Section 9124, is to say that we don't regard ourselves as giving you this authority. It already exists. It happens to be that that's the case law, that Aboriginal rights are independent and not created by Parliament, but Parliament has not said that. And to say that would be a big step for them, because then that means that some of the things that they regard as being in their sphere of jurisdiction, they can't control. And for provinces, it's going to be a big deal as well, in two respects. One, to think about the 92 heads of power, and to say we just don't have that kind of authority over you in those spheres, or we are willing to recognize your authority and resource you in that authority and understand that we don't have the ability to control you in the way that operates. That's going to be one challenge for the provinces. Another challenge for the provinces is if the federal government does act to recognize this sphere, it can create legislation that will be paramount to provincial legislation. And when the federal government preempts provincial action in Alberta or Quebec, that is not going to go well for a lot of folks. But this is the kind of thing that's been happening for 40 years in the United States. When federal governments act, they preempt both their own authority to a limited degree and state authority in the recognition that there's this other sphere of power there. This also is going to involve an economic redistribution towards Indigenous peoples. Right? If the Crown can't take up the mines and the forestry and the agricultural lands, that's going to be less money in their coffers from taxes and royalties. That's going to be more money in Indigenous peoples' hands to the extent that they develop them in the way that the province does, and I don't think they will always do that. That kind of redistribution is going to be a problem for folks, and is going to get in the way of the implementation of rights down this stream. It also is possible to regard this as domesticating the nation-to-nation relationship. Right? Indigenous people say, we aren't a part of Canada, the Haudenosaunee here. Right? We're allies of Canada. For you to create legislation that tries to implement our inherent rights is just crazy-making, right? It's not consistent with our theory of our relationship. And even those who regard themselves as being in a relationship with Canada through treaties and allowing for certain types of control or operation over their affairs, they often say, but our relationship's not with you, Ottawa. It's with the Crown and right of Great Britain. Right? And so bring this under that kind of rubric would be to, again, colonialize Indigenous peoples through a rights discourse, even through legislation. And of course, then there's the insecurity of legislation. We might get something done under this government, but a next government might come in and say, no, we don't like that. We don't agree with that theory. It's costing us too much money. We don't want to constrain ourselves in that way. The majority thinks otherwise, and suddenly that legislation's gone. It's been amazing that that's been sustained for 40 years under the United States, but we're in a different moment with President Trump. So far, so good with Indigenous people's legislative recognitions, but that's not to say that's going to carry on for the next 3 years. So, Indigenous peoples, though, also have something to do in this. Talked about this before. Article 1 of UNDRIP says, Indigenous peoples have the right to the full enjoyment as a collective or as individuals of all human rights and fundamental freedoms as recognized in the Charter of the United Nations, the Universal Declaration of Human Rights, and the International Human Rights Law. If Indigenous peoples have the right to expect these things of their governments, that's not just the federal government, it's not just the provincial government, it's also of their own governments. What are the obligations that Indigenous governments have to their citizens? Rights of religion, spiritual beliefs and practices, speech and expression, association, life, liberty. These are all in UNDRIP, these provisions. Property, family togetherness, a right not to be discriminated against by their governments. The privileges and immunities of citizenship. You can think about some of the challenges that Indigenous peoples are going through around blood quantum, membership, privileges and immunities of citizenship, language, education, labor fairness, administrative law provisions like notice, fairness, hearing, healthcare, gender equality. Right? If Indigenous peoples are serious about the rights paradigm and say, adopt UNDRIP, implement UNDRIP, federal, provincial government, well, someone tomorrow is going to turn around and say to them, you too. And to do that is going to challenge Indigenous peoples on that front. But it's to say that Indigenous peoples do have laws, and they hopefully, through these processes, can find ways to work in contemporary settings. Now, all this might be a reason for turning away from the state. Right? We can't do this through rights. They're contingent, they're colonial. When you implement them, they're always suspect. Because in making this point, beware of fundamentalisms, beware of putting all your eggs in one basket, as it were. And I think we should turn away from the state. I think it's important to do language revitalization and choose our different political forms that aren't always calibrated to the way the state is operating, and work in ways that we saw through Idle No More and other social activities, social activism, civil disobedience, etc. These are all important. But I would also say in that front, please beware of the danger of a single story, because the same kind of fundamentalisms that can creep into always turning to the state could also be in your own backyard if you look to self-help and the resurgence and revitalization of your own traditions. It's all to make the point of where I started, which is let's start in the messy groundedness of where we are and work towards better rather than worse places, and understand that there's risks in any direction that you turn. There's no metaphysically pure place that we can seek refuge from and in to be able to do this work. And that's a hard realization in this world, because sometimes what keeps Indigenous people's hopes and aspirations alive is, well, it wasn't like that once, and it can be different if we do it like that or in a modernized way again. And I say, yeah, it can be different, and we need to hold on to those beautiful things that we have in the past that are also in the present, but we also just need to inoculate ourselves that when that moment comes, when there's some spaces that are created for Indigenous peoples to do the things in the way that they would like to do them, we're not going to be conflict-free in that moment. It's just going to be another set of conflicts. And those conflicts require the same kind of analysis, the same kind of political will that's present in what I've been describing, even though it's been directed against the state. You can also find problems within. Although I do say power imbalances, though they are there, won't be quite the same. So, Indigenous rights as contingent, colonial, and legislatively fragile. Maybe not hopeful, but realistic. And what do we do with realism? It's what we've been engaged in these halls, is talk with one another. Be critical, be constructive, and find ways through these opportunities to not brush things under the rug, either from the state side or the Indigenous side. So I appreciate the time to be able to share these thoughts with you, and I welcome questions over the next 20 minutes or so.
Thank you very much. There are microphones on the two sides. So to speak at the microphone, you'll have to move yourself towards the microphone. And if you have difficulty moving, we can take a microphone to you. But Ron, why don't you start us?
Well, thank you for that talk. You ended on a relatively hopeful note, and I want to add another element of being dismal and depressed about the whole thing, because in my experience with the international realm, Indigenous peoples are really beginning to lose patience, I think, and they're losing patience over a key issue, and that is compliance. Right? So we have a lot of these legislative initiatives. A declaration is not something that Canada is compelled to report on to the United Nations. It doesn't come before the Universal Periodic Review. So it's aspirational. And it took 20 years to achieve. So there is this sense that the progress is very slow. What we have is aspirational, and the conditions that Indigenous peoples are facing in their day-to-day, according to what I've been told, have not really changed. We still have, in many parts of the world, we have mass killings, we have exclusions. In Canada, we have suicide crises, we have impoverished reserves. So at what point do these legislative initiatives spill out onto economic redistribution? You pointed to the possibilities of resource exploitation, which is, I think, inherent in the idea of free, prior, and informed consent, which is a more sort of robust process. But I wonder if you could address that as another of the impediments to the legislative approach to Indigenous rights.
Yes, so we live in a depressing world, right? But we also live in a beautiful world. I mean, that's the point I started out with. And so we need to fully take on board the fact that compliance is not a given under these international instruments, and even when you implement them legislatively. Indigenous peoples over the past 20 years have signed treaties that cover over close to half of Canada's landmass, like the Nunavut Agreement, etc. Those agreements are not always being fulfilled, right? You negotiate in good faith and you have resources and you still don't get compliance. So what brings compulsion Sometimes an enforcement order, if you get it domestically into legislation through a court, you can use the power of the court there to be able to allow for that kind of thing to occur. Also, though, the notion of law is then limited. It's not just about compulsion, right? Where is the persuasion? Where is the other mechanisms that aren't legal, right? The social, the artistic, etc. So I think we need to think about law more broadly as well.
Side, Genevieve.
Thank you so much for your talk, John. I had two questions. The first question is whether you could talk a little bit more about how Indigenous nations in Canada, like the Haudenosaunee, became treaty parties to UNDRIP if UNDRIP was being negotiated by the Canadian government. And my second question is whether it was possible that we might think about implementing legislation of conventions like UNDRIP by colonizing governments as implementing legislation about how to do settler colonialism, rather than about what it is that Indigenous nations have as their legal rights and obligations. And so whether there's just a whole category of implementing legislation we haven't thought about how to draft.
Yeah, so I think it is possible to regard both the negotiation of UNDRIP and its potential implementation by Canada as another exercise of settler colonialism to try to contain and constrain Indigenous peoples. And there's been criticism about the last article in UNDRIP that says it can't be interpreted in a way that would threaten the territorial integrity, the boundaries of the state. And then the implementation through this legislation also can be regarded as a domestication process. I don't know how you get outside of that loop other than what the document itself proclaims, which is the consultation, the discussion, because it is possible to think about having new treaties negotiated. There's a woman, Winona Sengel, teaches at the Michigan State University Law School. She's a Anishinaabe. She says that Indigenous people should get together amongst themselves and sign an intertribal treaty which recognizes and implements UNDRIP on their own terms. I think that's a fascinating description. It's in the San Diego Law Review for those that are interested in that way of thinking through this.
Please.
Maybe to carry on from that talk about the United Nations itself is a product of colonialism, and if we think about the laws here, and it is a colonial project, by the way, I'm a Palestinian, so I can tell you a lot about our engagement of the United Nations, understanding how it is a colonial tool that was implemented at the end of World War I to legalize the colonial imperial projects, and what we have here as common law is a framework to put civility, on the colonial project, camouflage the colonial project with civility. And so for me as a Palestinian and for us as a people that are in struggle with colonial laws and the United Nations as a structure, we view all these, the engagement with these laws as just an agitation to emphasize and highlight the contradictions between the imaginary civilized society that we live in and the reality of colonial imperial genocide that is happening. So even the United Nations agreement as itself will not happen, and any of these rights will not happen if people don't fight with them. This is ultimately what is the issue. If you engage the legal colonial systems, then you only engage them under the understanding that you're there to create the schisms and to highlight the contradictions, knowing that there is no good outcome that is going to come out of it. You're only giving it
yes,
legitimacy.
I would agree with that 100% and say, what's our alternative? There's many alternatives, but all the alternatives are also, in their own way, similarly compromised. And so we need to be criticizing what we're doing, you and I, and then we also need to be criticizing in other spaces, because it's not as if we turn there and suddenly we've got this magic, metaphysical, pure space that gives us the transcendence that we're seeking, at least in the political sphere. I'm not talking about religion, but we could add that for some people in this room. So I'm agreeing. And then the question is, what do we do about that? And I regard this as a strategic site. And to abandon the field is to also play a troubling game. Because you leave that to other folks that might be more accommodating or that might be less accommodating, depending on the side that you're looking at this on. And you suddenly lose the possibility for getting the little bits of things that might be there. You don't have to, some people believe you have to believe the game to play the game. And I understand the importance of being the change and walking the talk. And there are certain things that are unacceptable that you shouldn't play in that field or be involved in that game. But there are other things that are a little bit more complicated than that. And so working through the nuance of that means that we engage, hold our nose, and see what's possible, and then recognize that we're continuing pivoting out into other places to do the kind of work that we want to do.
Thank you, Professor Burrows. Wonderful lecture. I just wanted to, you touched on it a little bit in your answer to the previous question, but I just wanted to get your opinion on Article 46 of UNDRIP, which, as you mentioned, it kind of acts as a disclaimer almost. Nothing in this declaration can be interpreted as impairing or damaging the territorial integrity or sovereignty of the state, which, I mean, obviously strikes me that there's a lot of potential for settler colonies like Canada, Australia, New Zealand to fall back on that to actually contest Indigenous assertions of rights. So I just wanted to ask if you could talk about how you see that playing out in the case law and in the legislation and what strategies might be used to counter that.
Yeah, I think one of the best strategies in that regard is to live otherwise to it. So Anishinaabe people live in Quebec and Ontario, Manitoba, Saskatchewan, Michigan, Minnesota, Wisconsin, and because of the Jay Treaty, we can continue to go into the States and be associated with our relatives and neighbors there and learn from them and find ways to develop alliances, so that the territorial integrity of the states is a misnomer, because we have a territory that's divided by this artificial bound. And I think we can be more creative in that regard. But having said that, there's also another strand, again, not being a priori, but just responding strategically, that says this is the great news for Indigenous people, because most Indigenous peoples don't want to destroy the territorial boundaries of the states. That's not their job. That's not their objective in life. And so they can work with that assurance that it provides to folks that may be worried and say, that's just a red herring to think that we're going to break up the state of the United States or Canada and spend all our time worrying about that. Let's get onto the real stuff. And because that Article 46 is there, it's okay. You're going to be okay. We can do this in other ways.
Thank you.
Given the time, I'm going to suggest we take the next two interventions back to back, and then John will respond. So first.
Okay. Thank you very much for your great talk. My question is in terms of UNDRIP implementation. So you talk about how it's legislatively really fragile, and I was wondering if you could talk a bit to the alternatives to implementing UNDRIP, which maybe aren't legislative, or whether you think that the U.S. model of this legislation is the best way to go.
Yeah, I
We'll
don't.
take the second one from this side,
thank you.
if you would.
Oh, sorry. I guess my first question is about this sort of model that I guess you're painting of how we move away from federalist structures, and does someone in the James Bay Cree area identify with Quebec, and should Quebec have any right on a specific type of arrangement that it wants? And I guess that raises a question of federalism and how we move away from that. And it seems to me that this is very problematic. So I was thinking about, what does cooperative federalism mean? And Quebec itself has talked about asymmetric federalism, and so how would Indigenous people fit into that? How do they respond to that type of asymmetric federalism? And the second question is about your responses to Glenn Coulthard's work, where I feel like you're somewhat going these positions of resistance and turning away from the state, but he also talks about primitive accumulation and the value of Marx in kind of some of these economic questions. And I think this is, for me, what do we do economically with economic structures, and how do we challenge those ideas? And so I think that might help.
So just to go backwards then, I find value in Marx's analysis. And I think we should use that much more strongly. It's left our conversations, by and large, in the West right now as we're doing our work. But I also worry if Marx is picked up in the way that rights might be picked up, or Indigenous law might be picked up, or some other thing. And in some of the work that I see that's happening around Fanon, it's just the new savior, as it were. And I think, yeah, let's use it, but let's not get swept up by it. And so I agree that there's more that needs to be done on that front, even as we're careful about that. In terms of the federalism point, I think asymmetry is what's going to be necessary through this. We are a country that's designed around federalism, and I think we've limited our imagination by Section 91 and 92. And through land claims agreements, through other kinds of structures, we can continue to modify that, and maybe modify us in ways that aren't recognizable to us in 100 years from now through that incremental process, which then goes to the question about the implementation through legislation. I don't think legislation is actually the best way to implement what UNDRIP stands for. It's an option. It seems to be emerging for us right now in Canada in a way that it wasn't there before, but it's not the best option. There is no best option. Let's try it all out and reject or back away or drop something if that doesn't seem to work. There are negotiated alternatives. As I've talked about, Indigenous peoples can do their own thing to try to implement UNDRIP either intersocietally or within their communities. It's a possibility of trying to get international representation in a stronger way at that level, and through a permanent forum or something, create a recognition that pushes state sovereignty, and what that means at the international level, decentering state sovereignty by Indigenous peoples being regarded as one of the actors in that sphere. So I think that's partially an answer to that question about legislation.
I'd like to ask you for your commentary on the dish with one spoon concept as an alternative to the rather narrow definition of sovereignty. In other words, is there a principle of generosity that could be added to the mix here?
Yes. So I did my doctorate on these agreements, dish with one spoon, Tura Wampum, 1764 belt, 24 nations belt. And for me, that's where I spend most of my time, is working on those issues, because when that does is it opens up other ways of thinking about law: kindness, respect, generosity, love. If you've heard me speak in other contexts, I think we take seriously those ideas in Canadian law. What does it mean to have the spoon dish representation of law that puts us together in a relationship that involves respect? And we thought, well, how can you implement love? How can you implement truth or wisdom or bravery? And these are too vague, they're too vacuous, they're not precise enough. And my response is, welcome to the world of equality and liberty and life and security and association, right? These are vague concepts too. But putting these as aspirations, just as we do the Western concepts, could be very helpful to us and open up some other avenues as well. Again, not transcendent, but very, very valuable, for sure.
I want to thank you very much for your Humphrey lecture, which covered a huge terrain and moved on multiple levels. I think speaking very sensitively to first-year law students, to scholars of human rights. Thank you for challenging us, for inviting us to think differently about many things. Please join me in thanking John Borrows.
Thank you.